Authorization and point of consideration Doctrines. Dear audience, you must come here to learn something in point of consideration Doctrines. So those are the candidates of Shatra's busiest, the master of knowledge in terms of consideration Doctrines. And first, I would like to uphold my voice in terms of several doctrines. These are constitutional doctrines. There are many doctrines in terms of constitution. To comprehend in terms of constitution, we of all know or comprehend regarding that. Why? As an advocate with the barristers, judges, and for the Chief Justice, how high soever, you must have two grasp in terms of constitutional doctrines. So today's session on point of constitutional doctrines. At first I would like to focus regarding them serial by serial, and then I would like to discuss. First of all, these are the topics. Tanya Islam has prescribed that what is the name of exactly the topics? You know that the supreme law of the land, the constitution. So this constitution prescribes that several doctrines. And you know very well that Dr. Mohiuddin Farooqi versus Bangladesh, 49 DLR Appellate Division 165. Therefrom it is quite clear to you and to me that Constitution is the supreme law of the land. Yes, you are going to be an advocate, or the judges, or barristers, or the Chief Justice, how high soever. You must have knowledge in terms of the supreme law of the land. Yes, today's session on point of the constitutional doctrines. First of all, I would like to uphold my voice serial by serial. The name of that or these doctrines are pronounced by my mouth to you exactly. Oh yes, of course, this is the headlines. The first constitutional doctrine is doctrine of basic structure, and the doctrine of judicial review, and doctrine of political question, and doctrine of efficacy. You know, doctrine of efficacy or eclipse. And next is doctrine of necessity, and doctrine of severability, and doctrine of ultimaris, and the doctrine of natural justice. So those are the doctrines. And not only that, and doctrine of legitimate expectation. Dear audience, today's session on point of constitutional doctrines. So those who are the genius students in a society, they can grasp something or comprehend what I delivered today's session. So you of all, those who are not aware regarding this, the constitutional doctrines, you are nothing in our society. As an advocate, or the barristers, or the judges, or the Chief Justice, how high soever. So this is a very difficult session. Today's lesson is that in terms of constitutional doctrines. Exactly, I would like to focus several doctrines, and then the doctrine of classification, or now the term the doctrine of confidentiality, and doctrine of waiver, doctrine of separation of power, and doctrine of stare decisis, and doctrine of judicial review, doctrine of obiter dictum, doctrine of ratio decidendi, and the doctrine of what can say pleasure, and doctrine of legitimation. You know that the doctrine of presumption of innocence in terms of penal law, exactly upholding in our society. Doctrine of presumption of innocence. Until or unless you are proven guilty At that time, you are not allowed to speak in terms of that, what can say, the guilty. Or like the recent scenario in our country, that the systematic way in terms of Arab fact. Yes, that the several, what can say, journalists prescribe that Arab Khan is a criminal. He's a murderer in our society. Well, fine. But they have no concept in terms of that. Until or unless proven guilty, they are not allowed to speak in such a way. So that's why this is the doctrine of presumption of innocence that can be used in penal law or the penal code. So our session on point of constitutional doctrine exactly. I would like to focus in terms of constitutional doctrines. Those who are the students of law department, whether it's a public university or the private university or the national university, no problem. You must have knowledge in terms of constitutional doctrines at first. Then you have to click other subject. For example, CPC or the SR Act or the criminal, you know that the CRPC, Evidence Act, Limitation Act. Those are the latest proposition in our society. Exactly, we have to know, we have to comprehend that first in terms of the constitutional doctrines. So, dear audience, today's session on point of constitutional doctrines. And then, you know, that the doctrine of manslaughter. So, at first, we have to discuss regarding the doctrine of basic structure. Why this doctrine is very much important for you exactly to understand law. Yes, it is well settled that no one in the world is capable to define the law. Yes, but you have to focus in terms of basic structure. So today's session, at first, I would like to discuss regarding the basic structure doctrine. So what is this exactly? What do you mean by that very term? And in which, what can say, proposition or provisions in our constitution that the supreme law of the land are held. That doctrine. Okay, dear friends, let's move. We have to discuss regarding the doctrine of basic structure. The basic structure doctrine is a common law legal doctrine that the constitution of the sovereign state has certain characteristics or ingredients or elements that cannot be erased by its legislature. You know very well that there are three organs of government. Mr. Fuad Shahid. There are three organs of government. That the legislature, that the executive, or the judiciary. So the basic structure principles, you know, that cannot be erased by its legislature. You know, Parliament makes the law. You know very well that the enactment or the act is passed by the Parliament. But the judicial, you know, that the basic structure principle prescribe that cannot be erased by legislature. This is a systematic way. So, we have to focus in terms of basic structure of the Constitution. The doctrine is recognized in India at first. Let's have a look here. Mr. watching from Mymensingh. You are watching from Mymensingh, Ashik. You are the genius student in our society. Sultana is watching from the Manikans. You are the also genius student in our society. Those who are the genius, they can grasp what I delivered today session in terms of that. You are going to be a genius lawyer or the advocate or the barrister, but you have no controlling power or the delivering speak in terms of speaking English. You are nothing in our society. So you must have knowledge in terms of what can say speaking English, in terms of several what can say legal issues or legal arena or the legal doctrines. The first doctrines is in terms of basic structure of the Constitution. Why it is very much important for you to understand or comprehend that? Dear audience, please. Why? The reason behind this is the supreme law of the land. So you must have knowledge in terms of basic structure of the constitution that cannot be amended by the legislature. Okay, this principle is what can say recognized in India at first. This is a systematic way. And the basic structure principle is recognized in India, Bangladesh, Malaysia, Pakistan, and Uganda. So this is the systematic way through which you can easily grasp something. So Mr. Harun Rashid has come into force in what can say on the Facebook wall, the friend of mine. So today's session of the basic structure of the constitution, dear audience. That the basic structure of the constitution is recognized in India, Bangladesh, Pakistan, Malaysia, and Uganda. And not only that, it was developed by the Supreme Court of India at first. It was developed by the Supreme Court of India in a series of constitutional laws, constitutional cases like this, the Keshavananda Bharati versus State of Kerala, 1973. That is the All Indian Report, AIR. Oh my God, all are watching from Mamin Singh, Ashik. But in what can say in Bangladesh, you are not a good advocate or the genius advocate. So they cannot grasp something delivered by speaking power of mind from the side of Mr. Shafiq Nazrul. They actually, what can say, sacred cadets. They are bored to hear the language which is pronounced by Mr. Shafiq Nazrul. And that's why the viewers are less than that other classes which is focused by me in Bengali terms. But they have no grasping power to controlling power in terms of English speaking power. Whether this is the American accent or the UK accent, they have no controlling power to grasp or comprehend the nature. And that's why that the viewers or the audience is less than those of other sessions. So this is the systematic way. So Mr. Arthur has come here to please supply, please. Let's have a look. Now today's session on point of basic structure of the constitution. Okay. This doctrine is developed by the Supreme Court in India or of India in a what can say series of constitutional law cases in the 1960. Well, this is a point, please, code point to grasp something is that in 1960 and 1970, this is the code point, this is the year. What from this is the concept in terms of basic structure has been immersed. Okay, this practice is practiced in the whole world, like Malaysia, in Bangladesh, Pakistan, and Uganda. So this is the basic structure principle of the constitution. So you know very well there is a culminated, that culminated in Keshavananda Bharati versus State of Kerala, 1973. This is the landmark decision. What from we have received, we have gained a lot of knowledge. What do you mean by basic structure of the constitution? This is a good question from the side of literature. This is the apex of Bardic's position. So when the doctrine was formally adopted, Bangladesh is perhaps the only legal system in the whole world that the which recognizes this doctrine of its express, written and visit constitutional manner through Article 70 and that's what can say, wow, what's like a native speaker? Oh my God, my friend prescribed that, what's like a native speaker? So there is no bail of native speaker from the side of Mr. Shafiq Nazrul. You have no concept in terms of that. Whether it's American accent, with the UK accent, we are in apex of the verdict's position, Mr. Harun. Please prescribe your approach in terms of that. So Borjahan Chaudhary is watching now. So in Bangladesh, there is no point to grasp or comprehending nature to what can say, grasp or understand what I delivered today's session is that Mr. Nazmul has come in, what can say, has come here on the Facebook wall. But my friend, dear friend, how are you? Exactly, how do you do? Please press up your opinion on it on the Facebook wall. Our today's session on point of the several doctrines of the constellation. So now is the systematic way. In Keshavananda Bharati case, Justice Hansraj Khanna propounded that the Constitution of India has certain basic features that cannot be altered or destroyed through an amendment by the Parliament of India. Like this, our Constitution practices, our country actually practices this systematic way, which is brought from the constitutional brewing concept. Dear audience, the doctrine of basic structure, they have no concept exactly, and that's why they can't actually understand what I delivered today's session is. In Bangla class, they are gathered here, but you have no power to controlling power exactly. Who am I exactly? Yes, I'm a human being, you are the also, but you have no comprehending nature to grasp something, and that's why the audience is very much less than those of other sessions. They have no comprehending power exactly, and that's why they are separated, segregated from the side of the discussion, from the side of Shafiq Nazrul, and from the side of Lord Chair. Okay, our session is that Justice Khanna propounded that the Constitution of India has certain, certain basic features that cannot be amended by the Parliament of India. Likewise, our country exactly practices this systematic way. You know, this is the Keshavananda Bharati case. You know, another, landmark decision in that very A.K. Gopalan versus instead of, Madras. You know very well, Minerva Mail's case. This is also famous leading judgment in terms of basic structure. So what do you mean by basic structure of the constitution? Exactly from the side of Indian constitution, or the Bangladeshi constitution, the constitution of Bangladesh, the supreme law of the land, or the Uganda, Malaysia, and then Pakistan. Oh my God, we are always waiting for your lecture. Yes, you are waiting for my lecture, but you have no controlling power. They have no grasping power to discussion made. They have no power to grasp or comprehend what I delivered today. And that's why when the viewers are less than those of other sessions. They have no power to controlling exactly how to grasp something, how to comprehend something, how to understand something. And that's why the viewers are very much less. Today's session is that. So our session is that the basic structure. Yes, this is the Keshavananda Bharati versus the state of Kerala, that the first landmark decision in perspective to the Indian constitution. Yes, we are bringing the concept from the side of the Indian constitution. And sometimes you all know that the constitution brewing. Yes, that is the basic structure principle is brought from the side of the constitution, drafting from the side of Indian constitution in our country, like Bangladesh. Yes, this is the landmark decision. Well, Anwar Hussain Chaudhary versus Bangladesh. 49, why you know that the 41 DLR Appellate Division 165. At phase 165 is quite clear to you exactly in terms of basic structure. In our country, there is a supreme law like constitution. So there is several provisions of the constitution which are not amended by the parliament. For example, Article 7. You know that the second part of the constitution. So what do you mean by exactly focus in second part of the constitution? This is a core point. Here is quite clear to you exactly in terms of fundamental principle of state policy. So what are the fundamental principles of state policy? You know very well that the Article 8 to Article 25. Oh my God, Article 8 to from Article 8 to 25, those are the fundamental principles of state policy. Yes, you have no political pressure or the own power, or the own pressure to government to ensure those principles. In this respect, government is not responsible to apply to what can say enforce, reinforce in the what can say in Bangladesh. There's no what can say liability of government to ensure, to enforce the fundamental principle of state policy. Yes, those are the basic structure in our constitutional mandate. Dear audience, please like, comment and share just the expression from the side of the basic structure of the constitution. Oh my God. So we can easily grasp that the part of the second part of the constitution prescribes in terms of the basic structure. And the third part, please, let's have a look here. That the fundamental rights, please, it should be kept in mind that the fundamental principle of state policy, those are not enforceable before the code of law. Exactly. So why it actually derives, there's a landmark decision in this respect, that the fluctuation has come into force here. So no one actually comprehends what I delivered today's session is. This is not a mother tongue, and that's why this is an international language, and that's why they are what can say removing them from the side of the literature. They have no controlling power in terms of speaking powers. Yes, you are going to be an advocate, but you have no bill in our society. Until or unless you have no concept in terms of delivering speak, what can say standing before the Supreme Court, or the law courts, or the judge courts, you are nothing in our society. If not, you are not able to grasp, comprehend in terms of the discussion from the side of Shafiq Nasr. You're not genius, what can say lawyers or the barristers. You have no value in our society. Or if yes, how high soever, I have sometimes focused in terms of that the Chief Justice. You have no value in terms of what can say opposing powers. You have no concept in terms of delivering speaking powers like this international speak what can say language like this the English. This is the international language, but you have no concept in terms of that. Yes, you have no value in our society. What a pronunciation, mind-blowing. Yes, you have grasped that, mind-blowing. But you have actually no power to controlling oppose what I am exactly and who actually delivered today's session is and what angle actually I have focused. You have no will in our society. But the Lord actually prescribed that. You exactly, this is a systematic way from the side of Lord actually. No one in the world exactly, not in Bangladesh especially. Not in perspective as to the Bangladesh. In the world, just a way comparative study, you can't show any, what can say, second to none, like the Lord actor. That the approach from the side of Lord actor, they can't actually grasp or can't deliver his or her speaking in tracking this approaching power like this. So, dear audience, that the fluctuation has come into force from the side of you. No audience is actually still to hear the language of mine. Why? The reason behind this, you have no power to grasp something what I delivered today. Does someone say like the wow, presentation is wow, what can say mind blowing has come into force, but they have no concept. What can say they have no notion to grasp something what I delivered to this session is. Yes, someone in the world, let's say Hasibul Hassan has come here to see the approaching power, the laws, what can say, students of Dhaka University, Hasibul Hassan, the students of what can say, English department. Actually, he is entitled to, he is able to grasp something what I exactly delivered to this session is. Okay, our tone is in terms of the basic structure. Yes, the Article 7 prescribes that. Yes, the language has come into force like this. It is the poet who comes. It is the poet who comes, which is prescribed by Harun al-Rashid, that the Caliph of Baghdad. So, but in our country, exactly in Bangladesh, they can't understand that the Odommo Limited, they have no concept or the notion to actually the Odommo Limited will govern the crossing walls. They have no concept. But if they have any power in terms of who actually Rana Chakraborty Raj is watching, and today's session is Rana Chakraborty Raj is watching now. What from Rana Chakraborty, please tell me. Well, so the fundamental rights of the human being living in Bangladesh, exactly. That the Article 26 to exactly Article 47. Those are the articles which prescribes in terms of fundamental rights of the citizens of the people of, Bangladesh, exactly. Those are the fundamental rights. Yes, those are the basic structure of the constitution. Those are not mandated by the parliament. Why it can be immersed exactly from the side of the Anwar Hussain Chaudhary versus Bangladesh. For one dealer, Appellate Division, page number 165. Please open it at page 165 and that should be proved by you what I delivered today's session is. Yes, our discussed matter in terms of basic structure of the constitution. Not only that, now is the session on point of several actually doctrines of constitution, but we of all have no concept in terms of constitutional doctrines, and that's why we can't actually understand or comprehend that that the recent scenery like this, the Arab effect, but journalists in our country, but they have no concept in terms of the law related concept or the legal issues, and that's why they prescribe always that you are the murderer. Why? It cannot be prescribed through the process of journalists in our country. Due to lack of knowledge, they prescribe in such a way. Due to lack of knowledge, exactly. You can't say any culprit or the criminals until or unless proven guilty. You can't say that he is the murderer. That is called the doctrine of presumption of innocence. But unfortunately, due to the lack of knowledge, we prescribe that Arab Khan is a murderer. He's a Polish murderer. You can't say that in such a way until or unless proven guilty. You must have read, study in terms of law or the law background. But you are the journalist. But nothing is, who dares you? Exactly who actually give you this power to tell that? You have no power to express your opinion in terms of you are the murderer until or unless proven guilty. That is a natural law principle. And not only that, this is a concept from the side of the Latin maxims oriental parallel. But you have no concept. Yes, you are the, due to lack of knowledge, you prescribe that you are the victim and you are the culprit, you are the murderer, you are the harlot. No, you are not allowed to express in such a way. Why? The reason behind this, there is a doctrine. The doctrine, you must have knowledge in terms of doctrine of presumption of innocence. Yes, until or unless you are proven guilty, no one can prescribe in terms of that you are the murderer. You're not allowed. But it is a matter of grief that you are the journalist in your country. Actually, what angle you have to prescribe? You have no will. Exactly, sir. You lecturers like Dr. Zakir Naik. Oh my God, it is a pioneer in our society in terms of Islamic law. That the comparative study of Islamic laws. For example, Old Testament, that the Quranic declaration. That's the in terms of Bible, in terms of Gita, Shruti, Smriti, Bhaktam Ballot, in terms of adoption, in terms of the Muslim marriage, from the side of the that the Abdul Qadir versus Salima, 1886. This is the landmark decision in terms of Muslim marriages. Yeah, it is quite clear to you exactly that can be focused in terms of Muslim marriage as a civil contract, not a sacrament like a Hindu marriage. Yes, there's the Maurice Bukhari. They have concept in terms of several surahs in Quranic declaration. You're the pioneer in our society, but this channel will be stopped earlier. Why is exactly stopped that the channel which is focused from the Zakir Naik? Yes, it is quite clear to you, and it is very lucid to you that he is the genius in our society. You know very well that the Socrates, the name of Socrates, of course you have heard the name of Socrates. But how actually the position of systematic way to exactly dieting position or the death penalty to the hemlock. He's the genius, and that's why who is the what can say privileged society in our society, they want to know how to actually kill him. Why? He's genius, and that's why who are actually born in our society with genius, they are what can say in the position, they are the what can say red alert situation. Of course, I am the victim. I will be the victim in future life. It is boldly speaking from the side of Mr. Shafiq Losuri. So, our tone is in terms of basic structure. So, several actually the provisions of the Constitution that cannot be amended, like this Article 7, that the supremacy of the Constitution. Yes. And then fundamental principle of state policies, secularism, right to movement under Article 36, that the under the category of fundamental rights, right to what can say assembly, preventive detention, and that's a protection. That all are equal in the eye of law, equality before law. So those are the basic structure of the Constitution. Those are not amendable. Those cannot be amended. And those are the systematic way. So those are treated as the basic structure of the Constitution. Here it is. So it is quite clear to you exactly what do you mean by basic structure of the Constitution. Those are the basic structure. Those are not amendables. Those are not amended by the Act of Parliament. Those are treated as basic structure. So this is the first evolving measures which has emerged from the Indian leading case or the judgment or the landmark decision, Keshavananda Bharati versus State of Kerala, 1973, All Indian Report. To the page number 1461. Open at page 1461 from the side of Keshavananda Bharati versus State of Kerala. So it is quite clear to us that what do we mean by exactly basic structure of the Constitution. Alright, now our session on point of the doctrine of judicial review. But you have no concept in terms of doctrine of judicial review exactly. Yes, very hot today. So the fan should be actually on, and I would like to discuss after what can say cooling pan has emerged the cooling system. Please. Now the one can say focusing person tell us something to last amendment of the Constitution. Last amendment is 17th amendment of the Constitution. Last amendment. So what exactly happened in that very Constitution? This is totally known to you that the mother of humanity, Sheikh Hasina, prescribed that. 17. So what exactly happened in that very amendment? Okay, now the session is on point of judicial review, that the doctrine of judicial review. What do you mean by that very doctrine exactly? It's very simple to you exactly, please. Let's have a look here. You know very well, there are three organs of government. Well, first is executive, and the second one is legislature, and third one is the judiciary. Let's have a look. There it is. The executive, that the executive organs or the legislature, if they actually make any mistakes in terms of law making procedure, then the judiciary has come to resolve that matter. This is called judicial review, then the doctrine of judicial review. So this concept is actually first evolved in USA, America. In the famous landmark decision, Marbury versus Madison, 1803. You all know that. In Marbury versus Madison, that the doctrine of judicial review has been discussed in an excellent way. And this is known to you exactly, those who are the law students in our society. But unfortunately, this fluctuation has come into force today's session is, the audience is very much less, 3 only. Why? The reason behind this, you have no will in our society. You are going to be an advocate, but you have no power to grasp something, comprehend what exactly delivered by Mr. Shafiq Masroor. It is, oh my God, it is a matter of fantastic discussion. They can't actually exactly understand what I delivered today's session is, and that's why the audience is very much less than those of other session, Mr. Fuad. Why? Exactly, they have no bell, grasping power like this. What exactly delivered by me? They have no power to grasp something. And this is the reality in our society. No, actually, exactly, no one is the excellent, genius advocate in our society, or the barristers, or the Chief Justice. It is quite true, actually, that is 100% true matter. There's no hesitation in this regard. And you are also. And that's why fluctuation has come in. 2, 1, 2. Oh, the audience is 2, 1, 2, 2, 1, 2. Why?
Number of viewers.
Yeah, number of viewers is very much less than those of other sessions. Why exactly? They have no power. We are actually what can say illiterate people in Bangladesh. We're not skilled at home. And that's why this is the systematic way. They can't actually share the video. Why? They have no power to exactly understand what I exactly delivered today's session is. Yes. This is a systematic way. And that you are going to be an advocate. Why? What a matter. What exactly matter has come into force in our living life? You have no will exactly. Dear audience, you can't exactly shut down. Why? You have no will to grab something. What I delivered to this session is exactly. You know that the CPC, CRPC, Penal Code, you know that the Evidence Act. But if I say in terms of the what is punishment, the punishment is a sanction, such as fine, penalty, loss of property, assist against a person who has violated the law. The foreign concept from the Black Law Dictionary. Oh my God, oh my God. In the flag session 2, only 2 viewers, or the 3 viewers are still here. Why? They have no concept what I exactly delivered to this session is. Is that very much sorrow for us as a people, as the people of Bangladesh. Very much what can say grief for us. It's very, there is not lame excuse from the side of Lord Actor. So, this is the Lord Actor. This is the apex in, what can say, in verdicts, pinnacle situation. We are the best in terms of law, starting the law teaching arena. Fluctuation has come into force. Oh my God, 6 viewers are still now here. You have no will. Okay, so what do you mean by judicial review exactly? Judicial review means if the executive organ or the legislature have passed or the exercise, declarable exercise, ultra virus power, that time there is what can say, no, I cannot say yes, this is the power from the side of the poet exactly. It's a high in apex, but you have no concept exactly what I exactly delivered to this session is. And then the fluctuation, please, like here, 7 viewers are still here. Why? But they are going to be an advocate, barristers, or the Chief Justice, or the judges. But you have no will exactly in our society. If not. Oh, until or unless you are able to comprehend the language, the national language, yes, you have no will. Okay, no problem. Our session in terms of judicial review.
Going on.
Then the executive past or the executive exercises called power, the ultra virus power. That should be, what can say, polished electronic, oh, you know that the galvanized system from the side of judiciary. This is called judicial review. This is called judicial review. Yes, the act, you know very well, the laws passed by the parliament. Unfortunately, this laws is actually against the public policy. That should be galvanized by the judiciary. Yes, this is called judicial review. Actually, where from it is derived? This is the case law, like the landmark decision is that Marwari versus Medicine, 1803. This is a US landmark decision. But in our country, this is another landmark decision is that Anwar Hossain Chaudhary versus Bangladesh. You know very well. And the Dr. Mohiuddin Farooqi versus Bangladesh, 49 Dealer Appellate Division, page number 1. Qazi Mukhlesur Rahman versus State, that the 26th dealer. Oh my God. Oh, astonished. They are astonished what exactly been by Mr. Shafiq Nazir from the side of law doctor. Why? Why exactly, my friend? What? That they have no power, actually they have no comprehending, understanding power. They have no ability to understand what I exactly focus. So the fluctuation, 6, 2, 3, 6, 2. We have no understand the methods of Shafiq Nazrul. Yes, you have no understand the method of Shafiq Nazrul. Not only exactly method, but you have no power to grasp, comprehend what I exactly talking about. I'm talking to you exactly. Yes, we are talking in terms of basic structure of the constitution at first and then judicial review. What exactly? What do you mean by judicial review? Please mention your approach from the side of, yes, now Mr. Nasser Bradon has come to see something, watching something, to watch. Actually, with the view to watching something, Mr. Nasser Bradon has come here on the Facebook wall. Exactly. So, our discussed matter is basic structure of the constitution and the judicial review. Now, I would like to discuss in terms of doctrine of efficacy. What do you mean by doctrine of efficacy? Or the doctrine of necessity? Now, let's have a look here. In US, UK perspective, you know very well that the Leverson versus Anderson. Exactly what happened in that very landmark decision, Leverson versus Anderson. All the judges actually, they on behalf of the government, they write a judgment in terms of doctrine of necessity. They prescribe that it is a necessity, and that's why we are on behalf of government. But only one dissenting judgment has come from the side of Anderson. And in this respect, the jurist, famous jurist in the world, C.K. Allen, dear viewers, who prescribed that your judgment is far-reaching effect in the world that can be echoes standing on the, what can say, galaxy. You know very well, galaxies removing from what is day by day from the side of you. That the Elon Musk who wants to control the whole world, sitting on what can say, Mohakash. But a giant has come into force from the side of Elon Musk. But you have concept in terms of how actually get a salary, monthly salary has been paid by the government or the private sectors. Why? Exactly, you have no power in our society. And that's why you have no value in our society, exactly.
For a space station.
Why expects so Elon Musk wants to control the whole world. Sitting, what can say? Now what can say? Like this,
station.
Oh my God. So he actually prescribed this. So this is the borrowing words from the Proloid Paul. This is truly speaking is that. This is the reality. And sometimes I have focused in terms of that. Reality means the true sense which is existed in life. But you are going to be an advocate. But under the penalty, you are nothing in our society. Only senior will pay you 200 taka and you have option to take tea and what can say bread, nothing else. You are nothing in our society. Yes, you are the advocate, but so what? You are the barrister, so what? You are the judges, so what? You are the Chief Justice, so what? If not, actually until or unless you are able to grab something in terms of international speaking power, exactly in terms of international language like English speaking. But those who are law students, exactly, law teachers, they must have knowledge in terms of English doctrines. You know that the doctrines of constitutional doctrines are of many types. At first, I would like to focus on doctrine of basic structure, doctrine of judicial review, doctrine of efficacy, doctrine of eclipse, doctrine of what can say presumption of innocence. Already I have focused in terms of that. You are telling, you are a journalist in our society, but you have no power to control in power in terms of that Arab Khan is a murderer. No, you have no actually option to tell that. Why? The reason behind this, the doctrine of presumption of innocence. Yes, you have no power. But you are telling and telling, oh my God, blah, 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 blah. Why? Exactly, they have no power to grab something in terms of the doctrine of presumption of innocence. Until or unless that the accused, yes, the name exactly accused Arab Khan is proven guilty, you are not allowed to speak in such way that Arab Khan is a murderer. No. You are not allowed to speak in such way. Yes, this is the doctrine of presumption of innocence. And not only that, from the side of law doctor exactly, and the BCS Odommo, which exactly controls the causing world in future life, that should be proved. From the side of Shafiq Rasul, yes, I. But I is not pronounced in such way that the proudly, boldly speaking, prescribe that, but proud sign of the key. Okay, now the doctrine of necessity is the main tone of us, from the side of me. What do you mean by doctrine of necessity? You know very well that the Liberty versus Anderson, this is the UK case. So while it is quite clear to us, several, majority judges are on behalf of government, but only one judge is against the opinion of them. Yes, that can be termed as to the dissenting judgment. Anderson, this is a genius judge. And in tagging this view, Sig Allen, that the juries, famous juries who prescribe that, oh my God, your judgment has been raised in the whole world. And in court, who actually standing in the galaxy, Niharika, Fabuluka, all things in the gravitational apparatus, the standard value of G, you have Nobel exactly in terms of the judgment prescribed by you exactly. This is focused in the whole world. You can't say that my leg is broken. Only you are not allowed to speak in such a way that my leg is broken. At least 10% should prescribe that. Yes, your leg is broken. Yes, at that time that can be focused in such a way that the doctrine of necessity. But only one, you are telling that my leg is broken. Oh my God, my leg is broken. Mr. Fuad, the friend of mine, you are prescribed that my leg is broken.
My leg is broken.
Only you are the person. But no one prescribed that. You can't say that the doctrine of necessity. But the 10% or at least 5% or the 10, 20% have prescribed that, yes, oh my God, your leg is broken, oh my God, your leg is broken, yes, that can be proved. Yes, that should be focused in such a way that the doctrine of necessity. Yes, this discussion has been discussed in our country, like UK. In Bangladesh perspective, sometimes we have progressed. Irshad, the regime of Irshad prescribed that the doctrine of necessity. Mujib prescribed that the father of nation prescribed that doctrine of necessity. The fourth amendment, and the serial number 4, amendment 1 to 4. amendments of the constitution made by the father of the nation, Bangabandhu Sheikh Mujibur Rahman, who also actually prescribed that the doctrine of necessity. Yes, this is truly speaking is that the reality, that the Bakshal, you know very well that the Bakshal, creating Bakshal, of course, in that time, this is very much important. And that's why that should not be criticized by us exactly. That's the reality, you know. Reality means the true sense which is existed in life. The fluctuation has come into force like this, that two viewers are still here. Why? Oh my God, they can't actually grab something. They have no actually, what can say, tools in their pocket to understand what exactly delivering process by Mr. Shafiq Nazrul from the side of Lord Acteur. This is a very much, it is, what can I say, it is a matter of sorrow that we are in the age of darkness. Oh my God, we are living in the darkness. I am in Jahiliyyah. Oh my God. So this is the business policy in our society. If you have no power, controlling power in terms of speaking, like English is speaking power, you have nothing in our society. No, you have no bill. As an advocate, barristers, judges, chief justice, howsoever, you have no bill in our society. The books on point of law, exactly the book of laws are written in English. To those who are able or capable to grasp something and written skill in terms of English, they are the genius student of the law department, or the lawyers, or the advocates, barristers, judges, and chief justice, howsoever. Our chief justice prescribes that I have at least 16 years or 12 years to understand, to grasp something in terms of quashment under section 561A. That the quashing, how to quash something. So it is a matter of sorrow that we are living in I am in Jahiliyyah. We are living in
I am in Jahiliyyah.
Whether yes or not.
Definitely.
Definitely. They have no power to comprehend international law or international language. Yes, you have no power Arabic term. You have no concept. Ija ja'a Nasrullahi wal fath. What do you mean by that very term? They have no concept. And that's why fairness. You know that the fair is not found in his or her heart. Do you know that? Oh my God, we are living in the darkness. The age of darkness. I am a Jahiliyyah is failed. To grab something, viewers is only 5, 2, 1. Why? They have no power to understand what I deliver exactly. And this is the reality. And this is the reality. And reality means the true sense which is existed in life. So dear viewers, this is the Lord Acteur who we would like to govern, who we would like to, what can say, govern the full cosing world in future life. That should be proved. So you should be ready. We are coming very soon. Today is no more. Bye bye. Bye bye and bye bye. So Bundura, there is no prescribing powers in terms of speaking power. Exactly who we are in apex. Already that should be focused. Just you have to like this video and share done option has been focused by you, and then it will be very much helpful for you to be a great lawyer, advocate, barristers, judges, chief justice. So that should be focused. Oh my God, 2 viewers. What a fantastic discussion today's session is. What? 2 viewers exactly. This is the ridiculous made in our country. So this is the land which is successful land to actually initiate any business. So this is the, what can say, what is the weather, the climate. This climate is very much helpful, beneficial to us to actually initiate any business in terms of international speaking power. Exactly, English speaking power. Oh my God. What a fantastic 2 viewers. Oh my God. So today's session is on point of the doctrine of basic structure, doctrine of judicial review, doctrine of political caution, doctrine of necessity, doctrine of efficacy or the eclipse, doctrine of what can say complete justice, the doctrine of legitimate expectation. So it is very much important for you, those are the candidates of sure to, that the BCS, Bangladesh Judicial Service Commission, the written question pattern will be gathered from the side of the several doctrines of the Constitution. You must have knowledge in terms of the landmark decision in tracking this decision or the landmark decision of the, that should be leading cases. If you are able to grasp to write something in tracking those several discussion from the side of the constitutional doctrines, you are going to be a great judge in future life. So, dear viewers, please subscribe my channel and like, and all options prescribed by you exactly. You are going to be a genius judge in our society, genius advocate in our society. But I'm worrying with you, Ruhul Amin Shajib, you are worrying with you. Oh my God, you are the genius. Only 2 viewers are still watching this video. Why? So, I'm fed up to see the viewers caption. It's our bad luck that we don't speak English. Yes, it is a very bad luck for us not to deliver speaking power in terms of English speaking. Yes, you have no power in terms of native speaker like USA, America, or the UK perspective. But if you are the Bengali, yes, but you have no power to continuing power in terms of English speaking power. It's a bad luck that we don't speak in English. You have to focus in such a way. Okay, 2 viewers are very much less than those of our session. So Miraz Rajan is watching now. So Miraz Rajan, please, the genius teacher in our society, please tell me something in terms of the speaking power, in terms of the doctrine of basic structure of the Constitution, or the doctrine of judicial review, doctrine of efficacy, or the doctrine of necessity of the state, which is focused in terms of the liberty versus Anderson. This is the UK case, UK judgment, where it is quite clear to us, someone who says, who prescribes that my leg is broken. But you are not allowed to say that in such a way. Only you are the one. But someone, at least 5 persons, or the 10 persons, top 10, will prescribe that yes, your leg is broken. Yes, that time you should say in such a way that the doctrine of necessity. But in this case, it is quite clear to you that all the judges on behalf of the government, but only one judge who actually gave the dissenting judgment in that very judgment, case, that the landmark decision. In our bad luck, without speaking the Sheikh, who prescribed Ashik. So fluctuation has come into force from the side of 5 parts. Actually 5 viewers are still here. Why? The reason behind this, we are the, sir, to do something for us to speak in English. Yes, our course is still running. It's spoken English, not spoken. That should be pronounced in such a way that the spoken English is still running. There's the session from the side of the, English prescription. English, from the side of English doctor exactly. From the side of the, now we are like the turning in terms of the doctrine of necessity. And already we have discussed doctrine of basic structure from the past evolved judgment from the side of Indian case like the Keshavananda Bharati versus State of Kerala. That the All Indian Report 1971. 73. This is the Keshavananda Bharati case where it is quite clear to us that the doctrine of basic structure. The meaning of that doctrine of basic structure prescribed that there are several provisions of the Indian Constitution that should not be amended by the act of the parliament. This is treated as doctrine of basic structure. Likewise, our constitution. Actually, that the landmark decision in our country, the landmark decision, you know very well that the leading case, like that the Anwar Hussain Chaudhary versus Bangladesh, 41 JLR Appellate Division, page number 165. Open at page 165. And this is the landmark decision. Why it is quite clear to us. We have actually gathered a knowledge from the side of the Anwar Hussain case that the doctrine of basic structure prescribes that several provisions of our constitution that cannot be amended by the act of parliament. This is quite clear to you. Exactly. So, if the students, those are the candidates of the BCS or the Bar Council, you must have knowledge in terms of the constitutional doctrines. The first doctrine is constitution, you know that the basic structure, or the doctrine of judicial review, the doctrine of efficacy, or the eclipse, doctrine of severability, doctrine of necessity. Already I have focused in terms of that in tackling the landmark decision from the side of UK, like this that Liversidge versus Anderson. So all the judges are on behalf of government, but only one judge who are opponent, who actually gave dissenting judgment. Likewise, the CK Allen prescribed in that very judgment, it is quite clear to you exactly that one person has prescribed that, yes, my leg is broken. No, you are not allowed to say something. Likewise, only 5% or 10% who prescribed that, yes, oh my God, your leg is broken. Oh my God, your leg is broken. Yes. This is treated as doctrine of necessity. But you are telling that only one person who prescribed that my leg is broken. No. You have no will in our society to say something. You are not, what can say, you have no will. We are to, take this opportunity to this very option and taking this approaching power in terms of doctrine of necessity. Only one person has no will to say something. And in this proposition, like the jurist, the famous jurist in the world, you have all know that the very name, like the C.K. Allen, who prescribed that your judgment has a far-reaching effect in the world. Oh my God. Yes, dissenting, there is a value in our society that who actually dares to give such dissenting judgment. Viewers. So the flag session has come into force. Viewers are less than that of other session. Why? The reason behind this. Khadir Birombonachar. Yes. In our country, the international speaking power, they have no bail. Exactly, you are going to be advocate, barrister, judges, chief justice. But you have no power to grasp, comprehend in terms of delivering speaking power. Muhammad Kamal Hussain is watching here. So why? The flag session has come into force here. Only one viewer is still watching here. Oh my God. It is a matter of grief that we are living in Ayame Jahiliya. We are living in darkness. The highest darkness. Which is what can say failure darkness from the side of Makkah Medina. So you have no bail as an advocate in our society. So last of all, actually, first of all, we have posted several doctrines, the constitutional doctrines. Last of all, I would like to focus in terms of doctrine of manslayer. So this should be when the statutory provisions actually, there is option to neglect this manslayer. But in what can say to punish the offender is the provision of the penal code. The must have actually the opposing power from the side of manslayer, the guilty mind, that the Latin term, Latin phrase. So doctrine of manslayer is very much imperative to understand, to comprehend that. So we are living in Jahiliya. I am in Jahiliya. The Ayame has come into force Yawmun, the Arabic drum. The Ayama is a plural sense of Ayama. We are living in darkness. So today's Namo. Do you see next? Bye bye.